Thank you, ladies and gentlemen. You may be seated. Crouch, you may resume your questioning.
Agent Burkhart, as Mr. Lockhart was asking you some questions, he referred to some of the previous testimony that we've heard in this case. Do you remember the testimony of Miss Jessica Donnerstag?
I do.
And who is she?
She was the speech teacher.
Okay. And Mr. Lockhart asked you several questions pertaining to the use of logic and deduction in your investigation.
Correct.
What percentile of gross motor skills did Joe Clyde Daniels score in according to the testimony of Miss Donnerstag?
1% off.
Okay, 1 percentile of gross motor skills. And the defendant initially gave what statement about the movement of a coffee table?
But Joe Clyde moved it.
He moved it where?
To the door.
To the door, and then did what?
Agent, if you'll move that microphone closer to you to make sure.
Yes, sir. Yes, sir, Judge. Then moved it back.
Moved it to the door.
Yes.
Did he climb up on it?
Yes.
And did what?
Got a key.
A padlock key?
Yes.
And unlocked the padlock?
Unlocked the padlock.
And placed the key back on the mantle?
Yes.
And did what with the padlock?
Put it in the box of toys.
And then did what with the table?
Moved the table back.
Move the table back. Now, is it logical that a child scoring in the first percentile of gross motor skills would be able to move a coffee table across a room, through some toys, to a door, climb up, get a padlock key, unlock the padlock, put the key back, hide the padlock, push the table all the way back to the center of the room, leave the house without slamming the door, and escape completely without being heard? Is that logical?
It's not.
It's not logical. What did Miss Donnerstag testify to as when asked if Joe Clyde could do anything quietly?
That he couldn't.
And what was the defendant's statement about Joe Clyde exiting that rear door?
It was
How did he shut the door?
loudly.
Loudly. And what was the defendant's statement about people coming in and out the back door since his bedroom was next to the back door?
He could hear it.
Did anybody hear Joe Clyde escape?
No.
Logically, did Joe Clyde escape?
No.
Objection.
What's
He
the
can't
basis
ask.
of your objection?
He can't ask if he escaped. Logically, did he escape? He can say evidence doesn't point to that, say what the evidence is, but he can't give an opinion as to whether he escaped.
So your objection is as to the form of the question?
He's asking for an opinion as whether he escaped. That's an issue for the jury to decide.
Well, it is an objection, whether he characterizes it or not, to the form of the question and calling for him to make a conclusion. I would sustain it on the basis that it does, in fact, seem to be inappropriate in its form. You may restate your question.
Yes, sir. I'll move on. Did the defendant state that when Joe Clyde exits a door, he slams it?
Yes.
What did the defendant state about whether Joe Clyde liked rain or not?
Can you repeat that?
Yeah, the defendant was asked in one of his interviews whether Joe Clyde liked to play in the rain. What was his answer?
That he liked it.
That he liked rain?
Yes.
Or that he did not like rain?
No. Actually, I don't remember that.
Okay, and we can go back to that. And what did what did Miss Donnerstag say about whether or not Joe Clyde liked loud noises?
He didn't.
He did not. And was it thundering on this night?
Yes.
Was it lightning?
Yes.
Was it raining?
Yes.
Okay. What did the defendant say as to whether Joe Clyde had ever escaped once they started using the padlock on the back door?
Can you repeat that?
Yeah. Did the defendant was asked or made a statement in his first interview about Joe Clyde getting out of the house.
Right.
And that's why they start using a padlock. Had he gotten out of the house after they started using the padlock?
No.
No. What about did the defendant make a statement as whether Joe Clyde ever left at night at all?
No.
Never did.
No.
Never left at night? Never got out once they started using the padlock?
Correct.
Do all of these things go towards logic?
Yes.
I'm going to show you a map. Mr. Lockhart asked you a question about a report that was made at 1221 Gillian Hollow Road. You see that?
Yes.
Do you know how far Gillian Hollow Road is from the residence of the defendant?
It's in between. So we're looking at this map. You have Gillian Hollow Road up top, and you have Milltown Road down here to the left. It's roughly 7-8 miles.
Well, the distance.
Are you talking about? Are you talking about to
how
the?
far it is from the defendant's house to Gillian Hollow Road?
Yes, roughly.
About 0.7 miles.
Oh, you're talking. Yes, sir. Yes, sir.
About 0.7
Yes.
miles. In order to go from the defendant's home to Gillian Hollow Road,
Yes.
what highway is it has to be crossed?
Highway 70.
Is that a busy highway?
That's a very busy highway.
And Mr. Lockhart questioned about some boots that had been stolen from Gillian Hollow Road,
Correct.
and I believe he said a horse blanket that had been moved.
Yes.
All right, so in order for Joe Clyde to do that, he would have to travel which direction?
North
To where?
to Gillian Hollow Road across 70.
This highway.
Yes.
And steal a pair of boots.
Yes.
Now, was that investigated?
Yes.
And I want to refer you back to the investigation that was done in Gillian Hollow. Next slide. All right, and agents, you were in the courtroom when one of the detectives testified to the responses to Gillian Hollow Road, is that correct?
That's
I
correct.
believe that was testified to by Detective McCartney,
Yes.
and she said they responded to 1221 Gillian Hollow Road.
That's correct.
How many searches were done?
There were multiple searches done.
Next slide. And we referred to the CAD report that the complainant had called on 4/4/2018 at 1600 hours, made a report that there was movement in their barn. They checked the property, did not find anything, but they need to tell someone.
Correct.
Next slide. Same caller. Activity in her barn overnight. Puppies were let out of their pen. Horse blanket was moved to the birthing stall, and other things have been brought to her attention. Which is someone with dogs will come and pick up the scent. She does have a pond on her property. That's April 4th, 2018, 162507. Next slide. What is this?
This is the VCC log from TBI,
And what does the VCC stand for?
Virtual Crime Command Center.
And what was the response noted here?
Dixon County SO deputies Captain Gafford and Detective Troy Martin searched premises multiple times and did not find anything. They found claims that were made are unsubstantiated.
Okay, next slide. April 6, 2018. Same caller, again. Volunteer advised her sheriff wanted to speak with her, sent text to sheriff, her barn was tampered with. And on April 6, boots stolen. Now that was not noted in her first call 2 days before, was it?
It was not.
So April 6, boots were stolen,
Correct.
according to the call.
Yes.
Next slide. Someone was looking for her, but she was asleep and not even at the residence. Is that correct?
That's what it says.
Next slide. April 6, 2018, Gillian Hollow Road. Complaint on the way, the search of her property was conducted. Car 2 was dispatched into Angela with the complaint. Is that correct?
Correct.
So, then again, another search.
Yes.
And now you heard the testimony of Detective McCartney.
Yes.
She actually responded on April 4th.
Yes.
So we've got 3 searches that were conducted at the Gillian Hollow complainant's address.
Correct.
Is it logical to think that that place wasn't thoroughly searched?
No.
Now, going from Gillian Hollow Road, back to the map, please. If Joe Clyde Daniels had crossed Highway 70 onto Gillian Hollow Road, stolen boots, and then was seen again on April the 5th or 6th at Milltown Road, how far would he have to travel?
10.4 miles or the 9 miles.
10.4 miles or 9 miles. And would both of those routes take you through the command post?
Yes.
So is it logical to think that Baby Joe walked from Gillian Hollow Road on April the 5th through the command post all the way to Milltown Road?
No.
No. And let's look at actually what was reported on Milltown Road, because Mr. Lockhart has now brought it up a couple of times about this report in Humphreys County. I want you to take a second and familiarize yourself with this report. Ready? So the reporter called into the Humphreys County Sheriff's Office, is that correct?
That's correct.
And reported that a 4-year-old girl had seen a boy, is that right?
That's correct.
And what was the boy reported to be wearing?
Pajamas and shoes and had mud all over him.
Okay, so if that's true, if it's Baby Joe, Joe Clyde Daniels, he had discarded the stolen boots, thrown them away, and stolen another pair of shoes and made it over to Milltown Road.
Correct.
If this is Baby Joe, Joe Clyde Daniels.
Correct.
And what else was stated?
Said her daughter told her he kept saying he was 5, and then he would say he was 15.
Okay, and do you remember
Objection. Your Honor ruled we couldn't go into that. I didn't ask about it either. He knows he's violating the order of the court.
in response, Your Honor, I actually objected to him going into it right before we adjourned for lunch. Not only that, I've made several previous objections.
Ladies and gentlemen, step across the hallway, please. In a pretrial ruling, this court had held that report and the testimony of the mother of that child would not be admitted because it would essentially be secondhand hearsay. The report at the hearing that we held was that the child came in and told the mother's brother, her uncle, what she supposedly had seen, and that the child then was questioned when the brother told the mother, then the mother asked the child, and that the child repeated something on that order. It was excluded by this court because of the fact that the child was 4 at the time, and the mother said that she's now 8 or something on that order and didn't remember any of this. And I felt that that was a question as to the reliability of that information that would be suspect. In view of the fact I allowed that Mr. Lockhart be allowed to ask questions, limiting his questions about this report to allow him to show what he considered to be the lack of proper investigation, and he has repeatedly done that. In my opinion, the state should be allowed to ask questions of this witness that try to show, in response to the questions asked by the defense, why that was not found to be a credible report or why they didn't do more than what was alleged to have been done. Mr. Lockhart has asked repeatedly about whether or not they brought in dogs and whether or not they conducted a full-scale search in the area, or whether or not they searched the home of... Just be seated for a moment, Mr. Lockhart.
Yes,
I'll come to you in a moment. And that he has been allowed to do that on a repeated basis, and under the circumstances, it certainly seems to me that Mr. Crouch would be within his right in asking this witness, if I understand, and I'll have him ask him the questions he's about to ask him so that I can be certain as to whether or not that he found that to be credible using the logical deductive reasoning that Mr. Lockhart has referred to in the investigation, and whether or not that was found to be a credible report, and what additional reasons for an investigation would have been necessary. So let's have Mr. Crouch ask the question, and then I'll hear from both of you.
Agent Burkhart, in the course of this investigation and after the testimony in this case, the report that was made in Humphreys County, this 4-year-old girl reported that she saw a boy in pajamas wearing shoes, and the boy said to her, "I'm 5 years old, I'm 15 years old, I'm going to come back and play later." Does this seem credible or logical to you in light of what we know about Joe Clyde Daniels?
No.
Why not?
We can refer to the videos that were played during Jessica Donnerstag's testimony in regards to how he would speak.
Could he even say the word 15?
No.
Could he speak in complete sentences?
No.
That's my questions.
All right, Mr. Lockhart?
Show me in the report where he said, "I'll come back and play later."
Your Honor, I was referring to the testimony.
The testimony at the motion hearing?
Yes.
It's highlighted right there in front of you, Mr. Lockhart, if you look at it. And tagged.
Yeah. He said 5, then he also said 15, and then kind of just went back and forth. So, where did he say, "I'll come back and play later"?
I remember that. It's
Well-
not. Are you talking about in this report?
Yeah. I guess he's got you looking at the same thing I'm looking at. Where in it does it say that?
She said her daughter told her he kept saying he was 5 and then he would say he was 15. She said she asked her daughter when did she see the little boy, and she said it was yesterday or today. She could not remember.
So where
It does not
it
say
say?
in this. No, sir.
So when Mr. Crouch tried to get you to say, he said he'd come back and play later, and ask you if that was logical for him to say that, it's because he never said it, and nobody said he said it. Right? Nobody said the child said, "I'll come back and play later."
Judge, I'm going to object to the form of the question. They're talking about two different things. Mr. Burkhart is holding the Humphreys County Sheriff's Department report. I've referred Mr. Blocker to the transcript of Ms. Atkins' testimony in which she says the child said, "Come back and play later." They're on two different pages here.
Well, first and foremost, you're correct. My understanding is that he's referring to the report that was made to the Humphreys County Sheriff's Department.
Yes, it does not
And
say
if
that
you
here.
are referring to testimony that was given at a motion hearing in this case, then those are two different things, and they may have had different information in them. But be that as it may, it seems to me that he can ask the question of the officer whether he knows or does not know that that was said, and then he can respond without having to necessarily show where it was in that. If he knows it, he knows it. If he doesn't, he doesn't.
Your Honor, my question is, the court specifically ruled I could ask about the report and what the officers did or didn't do based on that. And I'm asking, how does that open it up now for them to go into the very statement that you ruled was not reliable and that we couldn't go into? We have followed the court's instruction.
The question, the basis for my ruling that the state would be allowed to do that would be that you introduce the idea of logic and deductive reasoning used in the investigation, and you've made this report and asked the officer about whether or not anyone followed up and what extent they did. You've asked that of multiple questions, which is a good lawyering. You're asking them what did they do, what did they not do. By term, the state should be allowed to then ask about logic and deductive reasoning and used in the investigation, and whether there was need to do more and why not. Would it not flow from that they have the right to explain why there wasn't a greater effort made in searching the areas that you have brought up?
So when I ask about what they did or didn't do, just because I say would it be logical to use a canine, then Your Honor saying that opens up hearsay that you previously ruled is unreliable. You're now saying they can do what I couldn't do.
I'm not saying that. What I'm saying is that you've introduced the idea of logic and deductive reasoning by the question used in the investigation, and used that in multiple examples with the witness to show why why something that was said wouldn't necessarily be true. What the state is attempting to do is to show through this witness why they didn't do a further investigation. And the idea that that I can give a jury instruction to the jury that they not be allowed to accept this statement as its truth, but rather it's being introduced to show the basis upon which the investigators found that it was not reliable enough to go further and do any further investigation.
If he lays a basis that this officer knew about these conversations when this transpired, then I agree. This officer wasn't even on the case at this time. So,
did you not ask the officer about whether or not there was an investigation made of that report and ask
yes,
whether or not?
Pursuant to your order.
Well,
and you told me that that's all I could do. I couldn't get into the statement. And you said it's not reliable. If you want to get into the statement, either side will have to bring the party in, subpoena the child. And I'm just asking, why is it different now for the state? Why shouldn't they have to bring the child in? That's what Your Honor told the defense. You can't go into the statement at all. You can ask about the report, how they investigated it. If you want the statement in, call the child and refresh your memory. And I'm just asking, why is it different now for the state than it was for the defense?
Mr. Crouch?
Judge, my response is that Mr. Lockhart, in some form or fashion throughout this trial, has mentioned this report on multiple occasions, I think 4 times, in depth at some points. I have objected at least twice. Mr. Turnbow tells me 3 times. But because every time he goes a little bit further in, there's no way for the state, without going into some depth of questioning with this agent, to rebut what he's throwing to the jury, which is this whole thing in Humphreys County went uninvestigated, without me asking these questions. I mean, and his questions of Agent Burkhart prior to lunch were, logically, wouldn't you have done this in Humphreys County? And I'm saying, logically, this child doesn't remember any of this now, is not available to testify, and what was said is completely inaccurate. I mean, how can I not go into that questioning at this point?
Well, can you not do that without asking the specifics of what the child said? Can you not ask the officer if, in using logic and deductive reasoning, why did they not make a further investigation of this?
Yes, sir.
Stating the very things that you just said without actually quoting the statements that the child made.
Yes, sir.
All right, let's do it that way.
You know, I still would ask that he lay a basis outside the jury as to back at this time when this report was made, if he was even aware of the report and can testify that he didn't take further action based on that. He can't testify why somebody else didn't do it.
Then why was he asked about it by Mr. Lockhart?
Well, and that's my take on it, is Mr. Lockhart opened that particular door by asking him about what logic and deductive reasoning would have led him to do regarding that kind of a report. So that will not be required to show a basis. He is the lead investigator on the case since he joined it, and he will be allowed to be asked by the state the same question about logic and deductive reasoning that the defense asked, and to show, without quoting what the statement was, why. You understand, Agent, that I'm not allowing you to testify about what supposedly this child said.
Yes, sir.
But the state can ask you questions about why there wasn't a greater investigation. All right.
And I'd ask the jury be instructed to disregard what he did say in regard to what the child said. That the court ruled that doesn't come in.
I'll instruct the jury.
Thank you, Your Honor.
Bring the jury back. Thank you. You may be seated. Ladies and gentlemen, a moment ago the question was asked and there was an objection that I wanted to take up outside your presence. I explained to you early on, sometimes that requires me to hear things and make decisions of what you should or should not be hearing. In pretrial motions in this case, I have made a determination regarding the specific instance that we're talking about and it involved a statement made by someone that I found to be, at that point, not reliable enough to be admitted. So the questions that have been brought forth by both sides are asking this officer to apply what's called logic and deductive reasoning in the investigation. So the state is going to be allowed to ask some questions, but they're not going to be allowed to repeat statements that I have ruled were not reliable enough, but they can question the officer about what steps they took and why they didn't take more steps in a particular situation. Does that make sense to you? And I want you to understand that you are to disregard any statements that you may have heard that this child, that 4-year-old or whatever it was, that made at the time. Mr. Crouch, you may address the jury. Oh, address the witness, rather.
Agent Burkhart, did Humphreys County Sheriff's Deputy respond to a complaint in Humphreys County
Yes.
on the day the complaint was received?
Yes.
Was that April the 6th of 2018?
Yes.
Did he do a report
He did.
on the property?
Yes.
And after that, multiple detectives also searched the area?
Correct.
Now, in this particular report, do you know the age of the person that reported to have seen a person?
Believe she was 4 years old. Oh, talking about the age of,
The person that witnessed another person walking down the road?
I believe it's 4 years old.
Thank you. All right. And if I could draw your attention back to the map one more time. So based on the questions asked to you before lunch, as to Joe Clyde Daniels leaving his home, going to Gillian Hollow Road, stealing boots, crossing highway, walking through the command post, 10 miles, and being seen on the 5th or the 6th. Is that logical?
It's not logical.
Let's talk about the questions and references to Mr. Matthew Leadford. Were canines run at the Leadford residence?
Yes.
When was that?
As on the 4th.
If I could turn your attention to, let me know when you're ready. When did Mr. Matthew Leadford's vehicle arrive home on the 3rd?
Roughly 10 p.m.
10 p.m. And did it leave the residence at any time that night?
It did not.
Was Matthew Leadford's in his driveway when law enforcement arrived on the morning of April 4th?
Yes, his car was.
Was his car and driveway blocked in by multiple Dixon County Sheriff's Office patrol vehicles?
Yes, it was.
Do you know when Mr. Leadford moved into this residence?
I believe it was the day of, the night before.
So that was the night of April the 3rd was his first night staying in this residence.
Correct.
Are you aware of other law enforcement that had contact with Mr. Leadford from April the 4th to April the 6th?
Yes.
And who was that?
Captain Randy Starkey.
Okay. And I want to show you a photograph. Can you identify this photograph?
Yes, I can.
And we're looking just off of that one for a second. What is this photograph?
This is a picture near the Daniels driveway, staying out near the road, but it's a picture looking back towards where the command post was, and in the middle of that is Matthew Leadford's driveway.
Okay, and if you could display that to the jury. Now that photo was taken by VCR, is that correct?
Yes.
On April the 7th.
Correct.
Now, are there still a lot of vehicles lining the road in front of Mr. Leadford's residence?
That is correct.
I mean, still 3 and 4 days after the fact?
Yes.
Okay. And now that's some handwriting at the top. And what does that say?
Matthew Leadford driveway, and it has an arrow pointing down depicting where the driveway is.
And that photograph was April 7th?
Yes.
I'll move that as the next exhibit.
It's going to be marked as 259.
And, Agent, do you remember the testimony of Mr. Chad Bailey?
I do.
And do you remember him identifying each of the residences where they ran canines?
Yes.
And is Mr. Matthew Leadford's address 1108 Garner Street?
Yes.
And those canines were run on the mid-morning or afternoon of April the 4th, 2018.
on the afternoon.
What was occurring in Mr. Leadford's backyard starting the morning of April the 4th for the next several days?
It's a search.
Search. Were other vehicles or aircraft moving about his house? Or close?
Yes.
In fact, were helicopters landing in his backyard?
Yes.
Were there a lot of people back and forth across his yard,
Yes, there was.
going from the command center to the residence of the defendant?
Yes.
Would you want to continue staying in a house in which helicopters were landing in your backyard?
After probably a certain amount of time, I would find that probably a little bit much,
Okay.
the noise.
Do you know if Mr. Leadford has been threatened on social media after his video interview was released in violation of a court order?
Yes.
He has been threatened?
Yes.
If you had been threatened on social media because something was leaked in violation of a court order, would you be very happy?
I would not.
Would you want to remain in a house in which the neighbors are suspect in a case like this?
I would not.
Did you have any probable cause whatsoever to suspect, any suspicion whatsoever, that Matthew Leadford was in any way involved in this case?
I did not.
I'll pass the witness.
At some point in this investigation, you and other agents considered the possibility that our client placed Joe Clyde Daniels in the trunk of his car, then called law enforcement and took the body away. Is that correct?
Where is that? Then, like in a report, or
No.
what are you talking
I'm
about?
asking you, did you and others discuss the possibility that the body of Joe Clyde Daniels was in the trunk of the car when he called 911?
Yes.
Okay.
This question is outside the scope of my redirect.
It's outside the scope of redirect. It seems to me to sustain the objection.
Your Honor, he asked questions about where the canine searched in the Daniels yard and the Leadford yard. I believe that this is relevant to where the canine searched, because I'm going to follow this up and ask him. Well, let's send the jury out and I'll explain to you what I want to ask you.
Ladies and gentlemen, step across the hallway, please. Mr. Lockhart?
All right, I believe you answered that yes, that was a possible theory that was discussed, that he may have actually had the body in the trunk when law enforcement was called out there. And you said yes.
Yes.
All right. And the canines that searched the Daniels property and the Leadford property, the one hit that we know of was in the back, a trail going from the back of the yard toward a pond.
That is correct.
And that's the only hit we know that canines made.
It's the only one that I'm aware of.
Okay. And the canine never did hit in the back area where Alex said that our client laid the apparently unconscious body of Joe Clyde Daniels.
No dog hit around the residence.
All right. And were canines taken over to run around Mr. Leadford's vehicle?
Around his residence.
All right. But did you have anybody search the trunk of his car?
I do not know if his vehicle or his car was searched. Not to my knowledge.
And so if it was a possibility that was looked at that Mr. Daniels had a body in the trunk of his car, same thing can be said of Mr. Leadford.
No.
No? Why could he not have put Joe Clyde Daniels' body in the trunk of his car?
Because Mr. Daniels confessed to the murder.
I understand.
Right.
We're contesting the validity of the confession.
Right.
I'm asking you factually and practically, could Mr. Leadford not have put the body in the trunk of his car and driven away just like you suspected at one time that Mr. Daniels did?
I do not believe that Mr. Leadford did that.
I didn't ask you what you believe. I'm asking you, could he have done that?
I'll object to speculation.
It's not speculation. I'm not asking them to speculate that he did it. If they believed and discussed the theory that my client did it, why cannot I ask him if there's not a possibility that Mr. Leadford did it?
Or anyone else that lived up and down the road?
No, just the next door neighbor that didn't want to give him his phone.
What about the Smithsons? You want to ask if they could have put him in the I don't understand how this is not beyond the scope of redirect or recross, rather, and outside the scope of what the state asked this officer. I thought you were going to be limiting it to the question about the dogs and asking whether or not they'd let the dog go around the Leadford property and around his car, and I think that would be permissible because it's within what the state asking, but I think you're going far beyond that now and asking questions about hypothesis of whether it's hypothetically possible that Matthew Leadford
I won't ask.
could have placed a body in the trunk of his car. And I believe that you are going beyond the scope of a recross when you do that. So you can ask about the dogs going around the Leadford property and whether they were around his car, but I don't think you can go beyond that about those hypothetical questions.
Well, I'm sorry, Your Honor. I didn't realize that on cross-examination I was limited. I know that the DA is on redirect, but I thought I could go into...
You thought, well, you think the rule doesn't apply to the defense regarding the outside the scope of redirect? Or recross?
Mine, outside the scope of redirect, I agree.
Well,
I think that the DA asked about canines and searching, that's opened it up for me to ask about canines and searching. And if Your Honor wants to limit me and say I can't ask if they checked the trunk of the car, I won't do that.
I am limiting you to
All
that
right.
extent. You can ask about the dogs that were asked on direct examination, and then you can ask any other question that directly relates to what the state asked on their last direct. Then let's bring the jury in. Thank you. You may be seated.
Just two more questions. Just ballpark, how many dogs did y'all have working in the search?
I know there was a lot, but I do not know how many.
And I believe you had dogs that could search for a live person, but also dogs that you call cadaver dogs. Is that correct?
There were different type of dogs out there.
Yeah, I'm not asking for
Yeah.
the number, but there's a bunch of dogs.
Yes.
Very thorough.
Yes, we did a
I
thorough
mean,
search.
meticulous search.
Yes, sir.
And not one dog indicated on the spot where Alex said that my client placed the unconscious or deceased body of Joe Clyde Daniels.
There was no, sir.
All right. Nothing further.
Anything further, Mr. Crouch? No. Thank you. You may step down, Agent. State may call your next witness.
Yeah, just one moment. The state rests its proof.
All right, ladies and gentlemen, the state has rested its proof. Anything I need to take up?
Well, yes, Your Honor, the normal motion we do and the move-on also.
All right, ladies and gentlemen, I have a couple of procedural things I have to deal with, so if you'll step across the hallway, we'll bring you back in just a moment.
Your Honor, we've discussed this yesterday with my client, but I'd still ask for a few minutes to go through. It's a very important right in regard to
Let
whether
me
he
give you a
testifies.
form.
Yes, Your Honor. May I approach?
Sound like here, bailiff can give it to you. This is the form for your client to consider his right to testify, and then we will come back to you at the appropriate time. Do you need about 10 or 15 minutes?
And I would like to do it privately,
No,
and then we'll go on the record, but this
that's
was.
fine. We'll let you step back in the holding area and talk with him. And then we'll take up any other motions at that, when we return at that point. So let's take about a 15-minute recess.
All rise.
Recording stopped.
Court will be in recess. Yes, ma'am. I've got to go. Court's in recess.